This is Wills and Trusts, how to avoid the three biggest mistakes. Let's wait another minute or so for the rest of the people to sign in. Okay, let's get started. Welcome to Wills and Trusts, how to avoid the three biggest mistakes. I'm attorney Robert Weaver from the law office of Robert Weaver. On this webinar, we're going to learn about how to avoid bad situations that we encounter all the time. Did you know that according to the AARP, the average estate loses 5 to 7% of its value going through probate? Not to mention potentially years of struggle and fighting with your family. I'm hosting this webinar to show you how you can avoid all that. So with that in mind, let me switch over to my slides and get started. I hope everybody can see my slides now. Good. Okay. We're going to go over California probate, the biggest mistakes, and how to plan for success. Those three areas. During this webinar, I promise to teach you how to make sure 100% of your assets go to the people you love, how to avoid California probate, the difference between a will and a living trust, why putting assets in your children's names may be a mistake, how to safeguard an inheritance from divorce, lawsuits, creditors, irresponsible spending, and more, and how to provide for a beneficiary who receives government benefits. And there's going to be important free gift offers from me at the end of this webinar. I'm going to give away a copy of the Estate Planning Efficiency Scorecard and also a digital asset checklist that can prove to be a valuable resource to use as you start your estate planning efforts. It's also the way to continue our relationship beyond this presentation. Please take a minute to act on it once we get to the end of this webinar. Who is Bob Weaver? I've been a San Diego attorney for over 40 years. I'm admitted to practice in both the California courts and the federal courts, including the U.S. Supreme Court. I focus on estate planning, probate, real estate, and business law. I am also a real estate broker and loan officer, well-versed in the inner workings of two of the biggest assets and liabilities in an estate. I believe that in law and in life, strategy and planning are the best ways to avoid potential pitfalls and worst-case scenarios. I look forward to your questions. You'll be seeing a box below this video that says Q&A. If you type anything in that box, it will come to us and we'll be getting to as many as possible at the end of my presentation. If I don't get to yours in this session, we'll do our best to answer you directly by email as soon as possible. We have a lot to talk about here, but I'm going to start with a story. A referral came to me from a real estate broker, and she was a beneficiary of an inheritance. There was no planning done except for a will. Why should they plan? Everyone thought that the decedent had almost nothing, no assets. But wait, we found an insurance policy that had paid out a lot of cash. With no trust, we had no alternative but to go through probate. The cost of the probate was around $8,000. It was a lengthy process, especially during COVID. The beneficiaries were scattered everywhere and notice requirements took extra time. To top it off, it was a recently drawn, hang on. Yeah, it was recently drawn will. And guess what? Most of the assets went to the caregiver. The family dynamic in the grieving process was not pretty. Like many attorneys that focus on estate planning, there are two ways that I can help people. One is in the capacity as a litigator, fighting against another attorney to prove whether you or most likely one of your family members has rights to something your parents owned. Now I'll be candid here. Many attorneys, including myself, make a lot of money doing this. But the reason I put this presentation together is because I don't want for you or your family members to go through it. Now, the other way I can help people is by assisting them in planning ahead. When someone plans ahead, there's much easier options to go through, which I'll get to later in this presentation. But first, let's start with the situation we're trying to avoid. The process of dividing up someone's assets after they pass away is known as probate. There are different rules for probate in different states. So we're obviously just going to focus here on California. What you have to realize is that the laws are meant to be fair. As you can imagine, there can be a lot at stake financially, and people will sometimes try to do sneaky things to get more than their fair share of a person's estate. We're talking about made up documents, forcing people to sign things under threat, and all kinds of stuff that you never dream of. So in order to avoid that, you either need to provide very specific instructions to the state on how you want your stuff to be handled, or it will go through a process where the state will handle it for you using their rules. Regardless of your wishes, if you don't have a plan or have a plan, but it doesn't hold up in court, you're going to go through the default situation, which is to split things up evenly. That means your bank account, your home, and basically everything you have. The estate is going to go to what's called a personal representative who will be chosen by the court. If they are specified in a will, that person is called an executor. The personal representative is responsible for settling any and settling assets and selling assets that have to be divided up. In California, an uncontested probate can easily eat up 2 to 5% of an estate's value, while contested probates get much more expensive with the additional attorney's fees. An estate with any value requires a personal representative. The fair market value of the assets will be determined by a referee, so there is no way to fudge these numbers. That basically applies to anyone who owns real estate, has been putting money into a retirement account, has a life insurance policy, or even a few nice cars. That's all money that isn't going to your family in the end. The overall process of probate takes a long time in California. We must secure court dates for hearings, appoint an executor for the will, and deal with anything that ends up being disputed. Sounds easy, right? Well, it can be when we have a simple situation, but those are very rare. When someone ends up passing away without a will or any record of their assets, the only person who has full picture of is not there anymore to guide the process. New assets can come into the picture. Situations with deeds and bank accounts you might have never known about will surface, and any one of them can be a change that interested beneficiaries want or don't want. And officially contacting all the interested parties is a major hassle. Typically, this ends up taking 12 to 18 months in California, even for a simple probate. And that's during the best of times. Due to COVID virus, the courts have been shut down for weeks at a time, opened up and shut down again. So if COVID keeps going, you could easily add another 6 months to that timeline for a probate. And beyond those fees, one of the nasty things about a probate is that the state law requires it to be put on the public record. If that wasn't bad enough, that your business and the value of your assets is put out into the world, which is a lot of people don't like. The whole purpose of this is to be fair to creditors. If you have a mortgage, you'd better believe that the bank's going to want to have a chat with your family about who's going to keep paying on it, what your credit history is, and if you've taken out loans for anything else. There are also less scrupulous folks out there, and they might make a claim or try to get some money out of the estate. Most of these don't make it through the court system, but it's a hassle. No one wants to go through with the death of a family member. The last and most important drawback to going through probate is the toll it takes on your family. Have you ever heard of a joke about families that don't speak to each other for weeks after a heated game of Monopoly? Well, dial that up to 11, because a probate is doing that with real money and houses. All the events that I've talked about in this section are stressful in and of themselves. Not to mention the fact that people need to grieve for the loss of a loved one. It's an absolute powder keg of emotions, and it really brings out the worst in some people. You may think you know your siblings or your kids, but I can tell you with certainty, there is no way to predict how they will act when there is money on the table. Probate proceedings can change lives, and it's rarely for the better. When you don't know and don't have a plan for how you want your wishes to be carried out. Your family will be in a contest of wills and sometimes a contest of attorneys, like I've seen in many cases. Families that battle it out in court most likely are not spending Christmas and holidays together anymore. And it's not something I want to see happen to other families. Sounds like probate isn't the way to go, right? I agree. But unfortunately, getting a plan in place isn't as easy as signing a piece of paper. Let me tell you another story and a few ways I see this going wrong. A friend came to me about their recent inheritance. There was an estate plan, but the beneficiaries were left in the dark about it. The plan was older and needed an amendment, but they never got around to changing it. Also, just because you have a trust doesn't mean it's being funded properly. These people forgot to add a new asset into the trust. The trust quickly outlived its usefulness because it never got updated or fully funded. Having an attorney to consult with when needed would have simplified the entire process. It's a one-way ticket to a lengthy probate process. In this case, we also had to use a court to get a feeble trustee removed because they were unable to do their duties. Wills and trusts are very powerful tools when used properly. But as you can see from that story, the devil is in the details. Can anyone who's passed the bar legally provide you with a will or trust? Yes. But as you can tell from this story, 99% correct will or trust, almost correct, can be worse than having no plan at all. I call this type of situation the yeah, I can do those attorneys for the situation where you hire an attorney for something else, let's say a traffic ticket or personal injury. And when you bring up a will, they mention, yeah, I can do those. You don't know if that last time that they did one of the estate plan or will was yesterday or 10 years ago. Besides being out of practice and missing details, the law itself changes. Any minor mistake can lock you into a structure you don't want. And if details are missed out, guess what? You're back to probate. You might be familiar with one of the many online services that allows you to get legal documents generated automatically for a small fee. These companies are relatively new, but the concept has been around for decades. Before LegalZoom, you were actually able to go get a blank physical will from Staples. And some states even provided these as a public service. Sounds like a great plan, right? I'll actually admit that it is. If you happen to have an incredibly simple situation, if you have no assets and no plans to deviate from the state's plan about dividing them equally, then they can work out. But the minute the situation changes, you have children, you have a home, you're gonna have to deal with a situation where such a document really can't protect you. By definition, these are one size fits all. Otherwise, how could they make such documents fit billions of people? Not to mention, the laws are different in all 50 states, but these documents are meant to fill and fit everyone. These documents are close to wording, but you don't want close here. That doesn't cut it. Another thing worth paying attention to is that in the name of the last page, you will see these documents getting invalidated after the time in court proceedings because they weren't updated or procedure wasn't followed to the letter to make them legitimate. The worst aspect of this, in my opinion, is that it gives you a false sense of security. You think you're fine, but when the day finally comes, you've doomed your family to probate. Remember when we mentioned that the law was in place to protect people from bad actors? One of the ways it does this is by having measures in place to prove that a document is legitimate. Otherwise, maybe a bad apple heir could come out of the blue with a document saying that the decedent left all of the assets to them. And there would be no way to contest it. So any will needs to be proven in order to be legitimate with the signatures of witnesses and a notarization. An issue that pops up frequently and one that often happens with do-it-yourself or inexperienced lawyer situations is not doing the witnesses correctly or not selecting the proper witnesses. If you don't go through the process correctly, and it can't be proven that the witnesses were present for the document signing, it will get thrown out of court the same way the document for a bad apple heir who wanted everything to get thrown, they'll get thrown out too. And guess what that leads you? Back to probate. This is more of a gray area. There's actually a process of finding the original witnesses, which can be crazier the more time passes away. People move, pass on, get old, and all sorts of things can make things complicated and expensive to resolve. Did you ever think a bad will could lead to bills for hiring out-of-state private investigators? Believe it or not, it happens, and this is why. This one is a bit more advanced. We're going to get to what a trust is in a bit, but in short, if you put your assets into a trust, you can avoid probating them when they are passed on. The problem is sometimes people get this set up and don't put their assets into the trust. This process is referred to as funding the trust. Any asset must be named and placed into the trust to be passed on, avoiding probate. If this is not done, all your beneficiaries end up getting is a piece of paper. That's obviously an extreme example, but oftentimes, if new assets end up coming into the picture and the trust isn't updated, those assets will end up going through probate. And this brings me to my next point. Life comes at you and situations change for both you and the law. The state law in California is constantly evolving, which is part of my job as an attorney to keep up on. Rules that were in place when a will was drafted may not hold up when a law changes. And on average, it will change every 3 to 5 years. And your situation will also change. a new house, a new child, divorce, etc. It's all stuff you need to stay on top of. If a plan isn't updated, you might have someone who was the best option years ago, but not now, being in control of your entire estate. A really common thing is you'll see with younger single people is naming their mom as a beneficiary for a will. Well, what happens when 54 years has passed by and mom is in a wheelchair or worse? This is the kind of thing that a focused estate law practice will be able to help you out with. That sometimes is less focused, usually when it won't have the same time. Attorneys that are less focused usually don't have that time to devote. Now let's change gears and show you how you can do this right. In this case, I got a referral from a bank executive. A widow was dying and didn't have an estate set of documents. She owned a house. The grown children realized that it was a dire situation and they all agreed planning and documentation needed to happen immediately. Everyone was stressed out. The son came to me to get a plan together. This was urgent, no time to spare. I put a trust in place in less than 24 hours. With a notary, I physically went to visit the mother. And luckily, mom was clear-headed and able to sign. She passed away a day and a half later. The family was able to grieve without the worry of probate or the disagreements about the distribution. Now, I have to apologize here because that doesn't make for a super exciting story like they refer to in plays or drama. But this did have a happy ending. And I'd like to imagine that most people don't want to have the story that they tell end up making bad guys out of their loved ones, because a time like that should be focused on being together, mourning, and moving on. My philosophy on estate planning is that I want everyone that walks into my office to leave with peace of mind. We've gone over a lot of ways that kind of thing can go wrong. But with the right plan in place, you'll be able to go through your life knowing that your wishes will be carried out no matter what happens. Another thing I firmly believe in is that peace of mind comes from the right plan for you. There's no ultimate estate plan that you can make. It's about what is right for you. Some people need Fort Knox to protect their assets. Some people need a picket fence. So let's go into the major ways to handle your estate. The first big document is a will. When done properly with the appropriate witnesses and all of the stuff we've gone over, a will is instructions to the court on how to divide your assets. Even more advanced estate plans include a will. One of the things to keep in mind, though, is that a will still requires your heirs to open a probate with all of the cost and exposure associated with that situation. The big hassle you're able to avoid with a will is how your assets will be divided. So assuming everything is done properly and is up to date, You can save your family the conflict of deciding who gets what, the longer timelines associated with hearings, and in most cases, avoid litigation between family members. A trust is a much more sophisticated document that gives you flexibility to divide your estate without going through probate. You can put your house, bank accounts, and anything else into the trust. And by passing the trust itself through a will, you're able to avoid probate entirely. Pretty cool, right? Trusts also allow you to choose how and when people receive their assets, which can be a very important thing in some situations. I'll give you a classic lawyer answer and say, it depends. Now, here are the major reasons I would recommend a trust over a will if someone walked into my office. I hope it seems clear by now, I'm not a fan of the probate process and what it does to families. Basically, if you have assets over $166,000, in addition to having to go through probate, you're going to be subject to potentially having 5% of your estate go to a third party. For most instances, this is the way above what it would cost to put an estate plan into practice. If you own your home, I always recommend a trust. Otherwise, you automatically go to probate. Because the home is a big asset and oftentimes tied to a lot of memories. It's one of the things you'll see fought over most in court. As we've gone over before, you may think you know your family, but it's very easy to get heated and fight over a house in court, which means more money spent during a probate, even if your heirs get along perfectly. You now have a situation where there are joint landlords with equal split. That is the default in state law. Everyone will have a portion of the home. If they decide to sell it, it's inevitable that one person will end up doing most of the work, which leads to further conflict down the line. By using a trust, you can set out specific rules for how you want your home to be handled, who to have it go to, how you want it sold, and who the proceeds would go to. And the list goes on. It's a much more flexible way to set up the rules in your own terms. Excuse me. So one group of people I always recommend getting a trust are those who have minor children. There are a lot of reasons surrounding guardianship, which frankly could be the subject of its own webinar. This is something that always raises eyebrows when I bring it up. Your kids will be getting everything the day that they turn 18. Now, I don't want to make any assumptions about you or your lifestyle, but I can tell you from my personal perspective, I was not at the peak of my fiscal responsibility the same year I graduated high school. The likelihood of your assets making life easier for your children goes dramatically down if they get to that age, and the chance of it actually hurting them at that age, getting that money through poor spending or dangerous habits goes up quite a bit. There aren't official studies on this, but a comparable situation I like to point to people is the lottery winner. Over 70% of them end up going broke within a few years, and over 1/3 go bankrupt after getting used to spending the money. All of this can be avoided by setting up rules for distribution in your trust. Don't let this happen to your kids. Another consideration for parents out there is what I call the kids protection plan. Let's say a couple is out on a date night and they end up getting into an accident. What's going to happen to their kids when the police call the house? They might have a great babysitter, but they probably aren't paying them enough to deal with that. The kids protection plan is specifically designed so that you are able to choose your own guardians to take care of your kids in the event of being temporarily incapacitated. Going back to that accident example, even if they're out of the hospital the next morning, I'm sure they don't want to have their children spend the night in state services, which, believe it or not, is the default situation if someone who doesn't have or specify a guardian. There's something I put in place for all of my clients with minor children because I think it's extremely important. So, special needs dependents can be in trouble if they end up receiving assets in a lump sum. There are big costs associated with caring for special needs people, and that will last their entire lifetime. In addition, we have state and federal programs to help pay for this. When a special needs person gets a big distribution in their bank account, it can kick them off of their benefits. They'll end up footing the bill for their own care until the money runs out, and then they'll have to get back on to the federal and state programs, back to square one. A much better situation is to get assets into a special needs trust that can be structured to make sure that they have money for care and other things in their life for as long as possible. Now, this one isn't super fun to talk about, but a big reason to have a trust. This represents a bucket of people that would be in a bad spot if they ended up getting a lot of money. If you have a dependent that has an active vice or maybe has had one in the past, money can be very dangerous. We're talking about stuff that like drinking problems, drug problems, gambling, bad business decisions, and that sort of thing. In some of these scenarios, the best outcome is the inheritance gets wiped out in short order. The worst case scenario can be life-threatening. When a probate or will is settled, the money will be given in a lump sum. But a trust can be used to set up rules as to when and how money is given out. A simple way to address this is by splitting the inheritance into annual or monthly payments. But you can get as complex as requiring stuff like drug tests in order to receive installments. This can turn a nightmare situation into a way to get people help and to do better for themselves, which is what it's all about anyway. So we've gone over how the default rules are for California are splitting things evenly, and they have limitations for a nuclear family. Well, those limitations become a lot worse when you consider the blended family. A lot of these rules were written when people didn't live to the age we do today. Divorce was not popular, it was very rare, and remarrying was even rarer. So if you have a blended family or children from a previous marriage, things can get very complicated very quickly. When we're talking about second marriages with children involved, almost no two situations are alike. And the default situation with probate almost never reflects a complex life situation. So if you want to have a second marriage or a blended family, I would highly recommend looking into a trust. People who own a business or are self-employed have a different level of risk than people who work regular jobs. In a word, it comes down to risk. If you take someone like a doctor who owns a small clinic, for example, you have exposure to lawsuits for malpractice, which inevitably come up over time. There are a number of business-specific structures that can help out with that, but having a trust in place can help you stop people from going after assets you want to pass on to your family in the event of something bad happening. In addition to this, the default rules of California probate can make your kids equal owners in your business or any stake in a business that you have. Most people I know have definite preferences in the terms of who they would want to have control of their businesses, to say the least. So I would definitely recommend a trust for that. This is what we do that you often won't get from other firms around us. We have up-to-date, state-of-the-art software to establish, upgrade, and conveniently make changes to a client's plan. We can help with digital assets. We can be authorized to keep everyone in the loop. We are happy to coordinate with other advisors. We can assist in trust administration. We can represent you in probate if you forget the plan or the plan doesn't work. Being a real estate broker and mortgage officer, I can seamlessly deal with often the two biggest estate assets and liabilities. Traveling to over 90 countries all over the world has given me a great appreciation for the diversity of peoples and cultures. I want to help people the best way I can. This is what I want to leave you with. We've talked about legal documents through this presentation, and I've told you some stories. I want you to think about what your story is going to be. What you set up with your plan or lack of a plan is the epilogue of the story of your life. We've gone over stories that end with families being torn apart. And if I can even have just one of you on this presentation stop that from being their legacy, I can consider all of this as having been worth it. So what's your story going to be? Now, let me answer some of the questions that have been coming in. Question. This sounds complicated. How long does all this take? Answer. Time it takes to do an estate plan is largely up to you. The turnaround time in my office is about 10 days from the time we determine the best strategy and plan of action. Question. I don't really have that large an estate. Do I really need a trust? Answer. If you're not married, you don't have children, don't own real estate, don't have more than $166,000 in assets, and don't anticipate any inheritance, then you probably don't need a trust. You still need a will. Who should get copies of, question, who should get copies of my estate plan? Answer, I keep a copy of the signed plan. I also suggest that the people who will carry out the plan duties have a copy. And sometimes if you want, you can give it to beneficiaries as well. Question, how much does it cost? Answer, the best estate plan is tailored to your unique facts and circumstances, and the cost depends on the complexity, and we discussed that up front. I can assure you that going through probate, being denied benefits, or having assets taken from you against your will is far more costly in time and money than planning ahead. If you can't plan ahead and later have to go through probate, I can still help you. It would just cost more. Well, that's all the time I have now for questions. We will answer any other questions by personal email, so send them in. If you've made it this far, something is resonating with you and we're here to help. As I promised, I have a special offer for you. If you received all you need from this webinar, thanks for listening and I wish you the best. For those